Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session. So to adjourn. God save the Constitution and His honorable court.
Good afternoon. Thank you for being here for our oral argument today in the 14th Court of Appeals. Our case today is cause number 14-19-00732, Civil, Houston Metro Ortho and Spine Surgery LLC versus Wansrich Limited. And if counsel would make their appearances for the record.
Good afternoon, Your Honor. David Gunn for the appellants, along with my colleague Joshua Smith.
May it please the court, Michael Young for the appellees.
All right. And Mr. Gunn, are you splitting argument with your colleague?
Yes, Your Honor. I'm going to argue to begin with and talk about the judgment that exists, the conversion claim, and leave the remaining claims to Mr. Smith.
Okay. And you wanted to split your time 10 and 5?
Yes, please.
Okay. All right, we are ready for your arguments when you are.
Thank you. Good afternoon, and may it please the court. My name is David Gunn. I'm here with my colleague Joshua Smith, and I want to tackle issue 1A in our opening brief, the conversion claim, because that's the basis for this very significant judgment. And we want to talk about two problems with the conversion claim, either of which should be the end of it. Number one, the claim actually sounds in contract, not tort. And number two, if it does sound in tort, conversion is not available for intangible property. So let me start with the first, because it's an umbrella point. Our argument, as you know from the briefing, comes from a long line of cases, Jim Walter Holmes, Delaney, DeWitt County, and so on. And I would like to shrink it down to two words, the two words you used in your Exxon versus Kinder Morgan case, respective rights. How do we know when contract governs and when it doesn't? And there's one sentence in Exxon versus Kinder Morgan that uses those two words. It says, when the contract spells out the parties' respective rights about a subject matter, the contract, not common law tort theories, governs any dispute about the subject matter. Well, those two words, respective rights, should sound familiar to you from the record because you will find them on the first page of our company agreement. On page 1 of our 48-page contract, at the top of the page in paragraph D, it says, the members desire to enter into this agreement to provide for the members' respective rights and obligations. Now, that, in our view, triggers the Exxon Kinder Morgan test. And as you said twice in Exxon, that contract spelled out the parties' quote, respective rights, happened to be regarding the processing of propane. Our company agreement does the same thing here. And if that is correct, that should be the end of the conversion claim, not the end of their case, not the end of their contract claim, but the end of their conversion claim.
How do you distinguish the first Court of Appeals opinion?
The MSM?
Yes.
Yes, in that case, there was just a gap. It did not deal with a right to buyback. Our contract, Your Honor, has a buyback right. It says here is exactly how the shares will be handled, what the price will be. And I think it's 3 times it says, this is the price you're getting, and we're not going to argue about that. Everybody agrees this is the price. So our contract, we think, covers the area, that it is comprehensive. And if this one isn't, I don't know how you can cover it. I think we've tried to cover it the best we could, and it's about as detailed as it could be. There are, of course, many cases in the contour area of law, but the first court case and the Cass case from El Paso are pretty far in the minority. I think the vast mainstream of decisions are represented by Exxon versus Kinder Morgan and cases like it. The other side says they have a slightly different test from the one you pronounced in Exxon against Kinder Morgan. They say it's about a 2-part test based on conduct. A conversion claim lies if the defendant's conduct breaches an obligation that exists independently of a contract and is not authorized by any plausible interpretation of the contract. And we just say, we've never heard of that test. We don't think it has support in the law. And you shouldn't adopt it because it will open the door to turning a lot of contract cases into tort cases. The proper test is the one from Kinder Morgan. Second point on the tort part of the case is even if a tort is available, it shouldn't be conversion. Whatever it is, this conversion claim shouldn't go anywhere. Your Robin Singh case is one in a line of cases. And I'd start with the Dallas court's decision in Express One, which says when you have intangibles, that's not the stuff of conversion, or without a very small exception. According to Express One, Texas law has never recognized a cause of action for conversion of intangible property, except in cases where an underlying intangible right has been merged into a document and the document has been converted. That argument was made to you. I won't read it from the appellee's brief, but it was made to you in Robin Singh. You accepted it. You repeated it in REHAC. I don't see that there's any way around it. The other side has some old cases about corporations. We don't think those apply to LLCs, and that rule should not be extended. The parties in Bauer and the old Rio Grande case had a right, they had an entitlement to the physical issuance of certificates. There is no such right here. And if you read the statute, I won't go into it, but 3.201 of the Business Organizations Code makes very clear. In corporations law, there's a presumptive right, unless the documents say otherwise, to have your interest certificated. It's the opposite with LLCs. There is no such background right. You don't have that right unless the documents say you do. Our documents don't. There's no such right here. Those cases don't apply. And that is, in our view, the end of the conversion claim. I'd like to yield to my colleague, Mr. Smith, for the other claims.
All right.
Your Honors, Wandsrich has pled several additional claims, the most significant of which is their contract claim for $7.8 million for their LLC units. In order to obtain anything more than $195,000 under the company agreement, Wandsrich must prove two separate facts. First, that it was operational, which is contractually defined to mean Medicare certified. And second, that Wandsrich's termination was non-adverse. In our view, Wandsrich can't prove either fact, but in my time with the court, I'd like to discuss the first issue, that of Medicare certification. Your Honors, there is no evidence that Metro has ever been Medicare certified. And because of that, Wandsrich instead convinced the trial court to hold that the issue had been judicially admitted. The purported admission fails for two reasons. First, it was not clear, deliberate, and unequivocal. And second, it was so unfounded that Wandsrich's own trial evidence disproved the admission at trial. On the first point, I'd like to emphasize the timeline that we've provided in tab 1 of the bench exhibits, which provide the context for viewing the judicial admission. This court held in Lentz Engineering, and the first court similarly held in the Spooner decision, that judicial admissions must be weighed against the record as a whole. This timeline provides the context for evaluating whether there was a clear and deliberate admission. Now, there are three aspects of this timeline that I'd like to emphasize. The first are the undisputed facts. The first two entries on the timeline are that Houston Metro's company agreement took effect on May 22nd, 2011, but that Metro itself did not open its doors until April of 2012. Those facts are proven by Wandsrich's own exhibits and are undisputed. The second point is that if you look to the next entry in the timeline, the key point there is what's missing. The purported admission that Wandsrich relies on is a statement by Metro's former counsel that Metro became little o operational on May 22nd, 2011. In the summary judgment hearing where that statement was uttered, and in the filings and PowerPoints associated with that, Medicare certification never came up. The word operational can have different meanings in different contexts, but the last thing on anyone's mind is Medicare certification. There's no indication that counsel meant that here.
So given the fact that the judge found the admission, if we conclude that the judge was incorrect in finding that admission, that would require a new trial.
Your Honor, the doctors are looking for the maximum relief possible. They're looking for closure. And based on the waiver of the admission, unlike many other matter of law determinations, The Supreme Court has been clear from Houston First versus Music and then its progeny that you don't have a right to rely on a judicial admission throughout the course of trial. You have to protect the record. That's exactly why Wandsrich managed to exclude 9 separate Metro witnesses who were willing to testify and prepared to testify that Metro has never been Medicare certified. But when Wandsrich disproved its own admission, you'll see the exhibit at tab 3, and there are others like it throughout the record, that Metro had not even opened its doors as of early 2011, meaning that it was a legal impossibility to be Medicare certified. Wandsrich re-injected that issue into trial, and they failed to carry the burden of proof. So the doctors want to get back to the practice of medicine without the distraction of this ongoing lawsuit. They asked the court for the maximum relief.
Just as it's difficult to prove a judicial admission, it's also difficult to prove a waiver.
Yes, Your Honor, that's true. And again, we're just asking the court for the maximum relief possible. At the bare minimum, we believe there is no judicial admission. And under the Houston First versus Music test, the mere submission of this evidence to the trial court constituted the waiver. Okay. Thank you, Your Honors. We ask the court to reverse the judgment and render that Wandsrich take only $195,000. Thank you.
All right, we are ready for you, Mr. Young.
May it please the court. In the limited time available, I'm going to address only a few of the issues in this appeal, but I of course stand ready to answer questions on any of the issues. Let's begin with conversion. The key fact on which the conversion recovery depends is that Wandsrich membership shares were not contractual rights. They were property rights conferred by the legislature, not by the company agreement. Now, it's true that the ownership of the shares did give rise to contractual rights as defined in the company agreement, but the conversion claim is not about those contractual rights. In its conversion claim, Wandsrich is not complaining that it got paid too late under the contract, that it got paid too little under the contract, or that it didn't receive some other contractual benefit. Instead, its conversion claim is based on a principle independent of the contract, but at the heart of the concept of property, that someone cannot confiscate a person's property and sell it to someone else. And that is what the trial court found the appellants had done here. Now, as explained in the MSMTBR case.
But wouldn't that turn any breach of contract into a conversion case? If I contracted with you and failed to pay you, wouldn't that be a conversion?
I don't have a property right in that payment. That's illustrated by the recent case cited out of the Dallas Court of Appeals, where the defendant stopped payment on a check for a contractual obligation. Merely failing to honor a contract doesn't violate a party's property rights.
I find your argument may be interesting, but if following that same logic, who did the conversion then? Was it the individual members that purchased, or was it the LLC itself that sold?
Your Honor, it was all of the above. First of all, Metro converted our interests by canceling our membership interests effective in November of 2014.
And that was accepted by your client, if I understand correctly, with an acknowledgement.
No, what was acknowledged and accepted was the termination, not the cancellation of the membership interests. And there's a very important distinction there. We remained members unless and until a contractual justification arose, namely the payment of the initial installment of the purchase price. That did not happen until November of 2017, long after the shares had been sold. But even if the membership interests, in any event, the membership interests were sold in August and October of 2015. That was an exercise of dominion and control over Wandsrich's shares by the company, and it was likewise an exercise of dominion and control by the purchasing doctors. So the answer to your Honor's question is both. Let me give an example. If I rent a car and I exercise dominion and control over that car during the rental term, a conversion claim will fail. Why? Because I have a contractual justification for my exercise of dominion and control over the car, even though it's someone else's property, and even though it would otherwise be tortious. But if I rent the car and exercise dominion and control over it after the expiration of the rental term, a conversion claim will succeed. It will succeed because I no longer have any right to dominion and control over the car, even if the rental contract provides that I agree to return the car at the end of the term, and even though the rental car company could sue me for breach of contract. This is one of those.
What if the rental car agreement said, for every day that you keep the car, you owe me another $75?
Then if it did not require me to return the car, then my possession would still be justified, and the car company would have a contract claim against me for the $75. But if I exercise dominion and control without a contractual justification for doing so, that is one of those situations that is both a breach of contract and a conversion. And why? Because the company's right to possess the car is not just a contract right. It is a property right derived from the fact that they own the car.
But wasn't there also contractual remedies here? For example, the members' rights cease on the purchase date?
The members' rights cease on the purchase date, which is defined as the date of the first of 5 annual installment payments. No annual installment payments or payments of any kind were made at least until November of 2017, when they tendered $195,000 to us. Prior to that, they had made no payments whatsoever, and the company agreement was very clear that our membership rights had not terminated. That happened long after the property was seized and sold.
So when they tendered the $195,000, was that before or after the sale to a different entity?
It was simultaneous with, they were all done the same day. The record doesn't show which one was done a few moments earlier than the other one. The conversion claim here is at its heart governed by the old Montgomery Ward versus Sharonbeck case, the case where the furnace repairman had a contract to make repairs, made them in a faulty manner, and burned somebody's house down. That claim sounded in tort, even though there was a repair contract, because the duty did not arise from the repair contract. The duty not to exercise dominion and control over someone else's property is a tort duty. It doesn't arise from the contract, and it doesn't become a contractual duty.
How do you distinguish the Exxon versus Kinder Morgan case from our court?
That case did not involve a property right. That case involved purely contractual rights. A distinction has to be drawn between the ownership of shares in an LLC, which is created by the legislature upon the naming of a member in the certificate of formation or upon the agreement of all members to admit a member. That then has certain incidents to it. The statute says that the company agreement can expand or contract those incidents, but the company agreement is not what confers the property right. The property right is conferred by the statute, specifically Business and Commerce Code 101-106A.
So would you say that every time someone fails to make a payment or fails to pay for something they purchased, creates this ownership interest, or is it just not non-payment pursuant to the contract? In other words, in temporal terms, at what point does it change from a property interest to a debt or a payment issue?
It changes at the moment that my right to exercise dominion and control over the property ceases and your right to begin to exercise those commences.
So looking at your agreement, doesn't it say that the determination of the occurrence of a terminating event and the categorization of such terminating event as either an adverse termination or not is made by the board?
Yes.
So wouldn't that be when that ownership interest becomes a debt interest?
No, Your Honor. It is governed by Section 4.3H, which specifically defines when the member's interest ceases. And it says it ceases on the purchase date, and the purchase date is defined as the initial payment date, which shall not be later than 90 days after the determination of the valuation price. So until they made that initial payment, there was no purchase date, and there was no cessation of Wansrich's membership rights. Now thereafter, if they don't pay the right amount, or if they don't make the second installment on time, that is a purely contract case, because the status of our property as property has ceased. To take the example given in the reply brief, if I buy a Porsche and the contract provides that title passes immediately, and I don't pay for the Porsche in accordance with the contract, that's a contract claim. But if the contract says you can drive my Porsche, but title doesn't pass until you pay for it, and then I don't pay for it, I'm not just breaching my contract, I am violating your property rights. That is the distinction. In this case, that's governed by 4.3H.
Well, when you buy a car from a dealership, title doesn't pass until you've paid it off. So are you telling me that they have a conversion claim against you? Against anyone who doesn't pay?
I respectfully disagree, Your Honor. Title passes immediately. Now, there may be a lien placed on the certificate of title to reflect to the world the existence of a security interest. But part of what I do when I sign the papers at the dealership is I make an application for title. Unless the contract says otherwise, I own the car immediately.
And what about when I'm leasing a car, which is very common right now?
Well,
if I'm leasing a car and I quit paying, is that a conversion?
Well, no, if I'm leasing the car and I have the right to exercise dominion and control over the car, then if I don't pay, that's a contract claim. But if, let's say, the lease term ends and I have no right to retain the car, and I do retain it, I would not only expect to be sued for conversion, I would expect the sheriff to come and arrest me for theft. If I may take just a moment to address the judicial admissions issue. The key principle of the judicial admissions doctrine is that the parties are not permitted to trifle with the courts by formally saying one thing one day and then saying the opposite thing the next day. Here, in an effort to obtain a summary judgment, counsel for Metro, not Mr. Gunn or Mr. Smith or their firm, but counsel for Metro, argued specifically that Metro had become operational in May of 2011. Not just once, but 3 times. Now, counsel did not capitalize the O in operational, but it is crystal clear from the context that he was referring to the capitalized term operational as used in the company agreement. That is the only way the summary judgment argument even makes sense. Now, we don't know why counsel chose to make that argument, but we do know it wasn't an accident. It wasn't a typographical error. It wasn't a slip of the tongue. It was a deliberate act to achieve a result for his client. And we also know that Metro, later represented by other counsel, chose not to withdraw the motion for summary judgment in which the statements were made. So by the time of the trial court's ruling, Metro was seeking summary judgment based on an assertion that it became operational in May of 2011, while getting ready to introduce evidence at trial that it had never become operational. This was trifling with the courts, and not just an isolated example of Metro's trifling with the courts. The history of the case showed repeatedly Metro saying one thing one moment and another thing the next moment as the exigencies of its position ebbed and flowed. Now, Metro's most fervent argument is that the admission is of an untrue fact, but that turns the judicial admissions doctrine inside out. If in fact the statement is untrue, then that accentuates rather than minimizes Metro's trifling with the courts. The law does not want litigants to assert untrue facts to obtain an advantage and simultaneously deny the truth of those facts. Be happy to answer questions about any other aspect of the case.
The summary judgment where the claimed admission was made, I thought that that had been denied.
No, Your Honor. It was still pending on the date of the pretrial conference where the court ruled on the judicial admission question. It was a different summary judgment that had been denied.
And was it set to be ruled on?
It had been argued and was pending decision.
And you sought discovery on this issue extensively after the motion for summary judgment was filed.
I wouldn't say extensively, but we did seek some discovery. At that point, we had no way of knowing if the motion was going to be granted or denied, and no way of knowing whether the statement would be ruled to be a judicial admission.
Any other questions? All right, thank you.
Thank you, Your Honor.
We'll have rebuttal now.
Your Honors, 3 points on rebuttal. The first concerns the appellee's very contract-based argument regarding when their property rights began and ended. And in response to Justice Zimmer's question on that point, if the court looks to section 4.3H of the company agreement, which Wandsrich emphasized, the court will see that the purchase date is not defined as the date on which payment is actually tendered, but rather as the date on which payment is due. In other words, the termination of Wandsrich's property rights, which is spelled out in section 4.3H, which says, notwithstanding any such delay in the payment of amounts due, the member's rights as a member shall cease on the purchase date. And the purchase date is the due date, not the actual historical payment date. And that, with this very contract-based argument, is when the property rights ceased. The second point, Your Honors, concerns this court's decision in Kinder Morgan. Now,
assuming that we agree with you on that, why was there a failure at the end of each calendar year to comply with the last sentence of paragraph H to make a up to 7.5% payment?
Your Honor, the Metro and the doctors were relying on a separate provision, section 4.3F, which states that when there is an adverse terminating event, the parties have up to 3 years to tender payment for the shares. So they were relying.
Is it 3 years to tender payment or 3 years to provide written notice?
It's 3 years to provide written notice and provide payment was our client's interpretation of the document.
But
And
I understand that. That may have been their interpretation, but we're looking at what the document says. And paragraph H is the payment paragraph, whereas I think you're looking at paragraph D for a determination. I'm sorry, paragraph F.
yes, Your Honor, and section 4.3F states, here it is.
That's the
It
3
states-
years, the written notice within 3 years.
Yes, Your Honor, and it states the member must sell as of the effective date, even though notice doesn't happen until 3 years later. So in other words, the transaction is taking place from a payment standpoint at the time that notice is given.
Well,
Whereas-
notice was given very early on that he was fired. That was the notice.
Well, I'd like to step back, Your Honors, and the big picture here is we're talking about how to interpret this contract. And our clients understood the contract to provide that they had 3 years. To the extent that there are any concerns about their interpretation of the contract, it's precisely that, a contract issue. And this court's decision in Kinder Morgan makes exactly that point. That case was not just about contract rights. That case involved a property interest in chattel, in propane. And I'd like to point the court's attention to, now I've mixed up the pages, but to page 128 of the Court of Appeals decision, of this court's decision in that case, where the court said that if the property rights were the end of the analysis, then there would be no point in having an independent injury rule. This court specifically rejected the very argument that Wansrich is making, that just because there's a property right, that's the end of the matter. Here, the parties carefully contracted about the scope, nature, details of their membership interests, when payment was due, and even to your question, Justice Christopher, the result of delays in payment, the interest rate. And that is exactly what should govern the parties' dispute here. The final point, Your Honors, regarding the judicial admission. Wansrich talks about the importance of candor with the court. We suggest that Wansrich should begin with its own filing with the court, which we've attached as tab B of the bench exhibits, where Wansrich expressly told the trial court that Metro denied Medicare certification. And this was prior to Wansrich ever hinting that there had been a judicial admission. Your Honors, it's crystal clear that Metro was never Medicare certified. Therefore, the contractual formula, which requires only $195,000 to be paid, is the sole amount that Wansrich should recover under that agreement. Thank you.
I have, before you leave, I have one question on the attorney's fees for the non-compete.
Yes, Your Honor.
So you are not bringing as a point of error that the summary judgment with respect to the non-compete was incorrect.
That's technically true in the sense that we are not asking this court to reinstate our affirmative claim for damages for breach of the non-compete. But to the extent that the issue overlaps with that of whether or not the non-compete is enforceable, we have briefed that fully, and we are asking this court to hold as an alternative ground on the adverse, non-adverse issue, and with respect to attorney's fees itself, that the document was not unenforceable. It fully complied with the statute.
Well, I'm not talking about the adverse is non-adverse. I'm talking about the unenforceability of the non-compete.
Yes, Your Honor. So when it comes to the motion for attorney's fees, there are only two grounds, or the only ground on which Wansrich could recover those fees is 15.51C of the Business and Commerce Code. And that has several elements. The first being that the non-compete is an agreement for that the non-compete is located in an agreement for personal services.
All right, and that was found against you by summary judgment, and you're not contesting that finding.
The personal services issue was not addressed via the summary judgment on whether or not the non-compete was unenforceable. Those were separate motions, separate issues. There was first, the trial judge ruled that it's unenforceable. And second, later on, it granted Wansrich's motion for fees and implicitly holding as a matter of law that the primary purpose of the document was for personal services, which
Well,
just
was this motion for fees in effect a motion for summary judgment on this point?
I think it could be treated as such, but Wansrich has said that the court should treat it as if it were presented at trial. And we asked the court to hold that there is no legally sufficient evidence in any way that either this was a personal services agreement or that the doctors or Metro had any knowledge that it exceeded the bounds of reasonableness, because it was enforceable to begin with. And for those reasons, we asked this court to eliminate the fee recovery as well.
Thank you. Thank you for those very interesting arguments. And the case is submitted and we are adjourned.
Thank you.